Hey out there, legal warriors. In this video, I'm going to cover the question of why it is important that you respond to a protection order in Washington State. Now, a lot of people call them restraining orders. In Washington State, they're called protection orders, and it's really important that you don't fail to appear for that. Not because you'll get a warrant, but for another reason. If you're interested in this area of the law, stay tuned. This is the video for you. My name is Attorney Lance Fryrear. I'm a defense attorney in Linwood, Washington. My law firm's been defending people charged with crimes all throughout Washington State for more than 20 years, and I'm putting out these videos to help educate the public. So if you find this useful, please like and please subscribe. More people will get to see it. More people get the help they need. Now, as always, I'm just going to jump right into it. So in Washington State, there's a law that allows one human to ask that another human be restrained based upon supposed actions of the person that's supposedly doing the no-nos. Okay, and in this state, there's a protection order statute. It's under RCW 7.105. And the person who's aggrieved and mad is called the petitioner, and the person who the petitioner is trying to restrain is called the respondent. And before I can get into why the respondent needs to not fail to appear for a protection order, or what can happen if they do, what the downside is, I sort of need to explain the process. So in this state, there's a bunch of different types of protection orders. There's domestic violence protection orders, anti-harassment protection orders, SA protection orders. There is also anti-stalking protection orders, amongst a few others. But the most common ones you're going to see would be domestic violence. That's family or household members restraining each other, or anti-harassment. That's generally everyone else restraining each other. And there's different necessary proofs for that, and I'm not here to talk about the proof for each type of one, but in each order, what happens is the petitioner fills out a petition for the protection order, and they file it with whatever the relevant court is. Courts can vary based upon where the complaint of actions happened, where the petitioner lives, or where the respondent lives. And when they file that with the court, there's an ex parte hearing. Ex parte means one party only. The respondent side doesn't get any notice. And so the petitioner tells the court why they want the order, and typically the court is going to order a temporary protection order, what some people might call a temporary restraining order. Again, that's not what we call it in Washington, but that's what the public calls it. And how that works then is the respondent is now having their freedoms restrained upon pain of arrest if they violate the order. If the court doesn't think there's enough for an immediate restraint, they can also just set a show cause hearing, a hearing where the respondent is told to appear to answer for the petition complaints without any restraints. But in either way, there's going to be a hearing set, typically 2 weeks after the petitioner files their request and the court takes action. And so what typically happens then is that in some way the respondent is served with the notice of this new hearing. They'll get the temporary order served on them, which now restrains their freedoms, or they'll get the show cause notice, which doesn't restrain freedoms, but tells them show up for this court date or we're going to restrain your freedoms. And that court date, when by the time you get a notice, it might be tomorrow, it might be 5 days from now, it might be 10 days from now. But when you get served with that paperwork, typically by a police officer, but not always, make sure you look at it and you see what you're told not to do and what you're told to do, which is show up on a certain court date. So what happens at that permanent protection order hearing? Permanent doesn't mean forever. It just means after a chance for everybody to hear. It's not the temporary side. We get to hear both sides now. What happens there is that the respondent gets to say why the court should not issue an order, and the petitioner gets to say even more of why they want their order. Now, there needs to be stuff done in writing and stuff like that ahead of time, and that's not the purpose of this video. There's a bunch of other videos on this channel that's going to talk about that. But the respondent has a decision to make. The respondent gets the paperwork, and they're mad, right? And they look at the date that's coming up in a week or so, and now they look at the petition. And the petition has a spot where the petitioner asks for a whole bunch of different things. They might ask that the respondent be ordered to do a mental health evaluation, or that the respondent be ordered into domestic violence treatment, or the respondent has to give up their firearms, or the respondent has to wear a GPS monitor and the government gets to know where they're at all times. There's all these things on the request. It could be possession of cars or pets or custody of children, all these type of things. And when you look at the temporary order that the court issued, typically in this case, most of those boxes, they don't say you are ordered to do the treatment. They say reserved for the hearing, reserved for the hearing, reserved for the hearing. And some people think that, hey, I just don't want to deal with this. I'm not going to contact the petitioner anyway. I want them out of my life. So it's just simpler if I don't show up. And so what happens if the respondent does not show up for a protection order hearing if they've been properly served? I won't get into too much of the weeds here. There's always a bunch of examples of this has to apply and that has to apply. But basically, the court cannot issue a default, a no-show order against a respondent unless there's proof in the file that the respondent was served with the paperwork 5 court days before the permanent order hearing. If there happens to be that's typically a week then, right? 2 weekend days and 5 court days. So 7 days ahead of time. Now, if there happens to be a court holiday in there or 2 court holidays, add more days, right? If it's Memorial Day runs in the 7 days, well, it's really 8 days because it's 5 court days. So assuming the court has proof in the file that the respondent was served 5 court days or more ahead of time, when the case is called, if the respondent is not there to respond, they don't appear. Now the petitioner is going to win their case by default. Well, why do I care, Lance? In this hypothetical, I said I don't want to have contact anyway. Well, here's what happens. If you're not there to put up any fight, oftentimes that judicial officer, a commissioner, or a judge, they're just like, yeah, what do you want? Well, they're not responding, so they must not care. What do you want? And now it's much more likely that bad things will happen to you, right? Maybe they do order domestic violence treatment when typically the court doesn't often order that. Maybe they do order you to wear a GPS monitor. Maybe they do order you to do a mental health evaluation or an alcohol or drug evaluation. All these things because, they're seeing all these bad things in the petition, this evil respondent that they're claiming that you are, and there's no one there to say otherwise. And this law's been around for a couple years. It's a terrible law. I'm on record. It's a terrible law, in my opinion. And it used to be, and in some courts still just be, hey, I'm just going to give you the bare minimums. It's an FTA. The guy didn't show. The gal didn't show. I'm just going to give you the bare minimums. But nowadays, I've seen more and more, depending on what court it is, to go, what do you want? And oftentimes, if you show up, the worst case scenario, quite often, is they're going to issue a 1-year protection order against you. They can get more, and I've seen cases where they've issued lifetime orders on a hearing, but that's out of the ordinary. If you don't happen to be there, if you don't show up at the hearing, it's much more likely that the court's going to issue an order that lasts longer than 1 year. Now, take a look at the petition. I think it's number 15 on the number of options on the petition, item 15. If I got that right, I've been reading way too many petitions, that says the length of the order that the petitioner wants. If they check for only 1 year, the court should only grant them 1 year, but they don't have to. If you don't show up, they can grant more because judges do what they want. So some people think if they don't show for a protection order hearing, they're going to get a warrant for their arrest. That's not true. You won't get a warrant. This is not a criminal matter. This is not the government versus the respondent. It's petitioner versus respondent. But the petitioner will get a default order. And while the upside is there's less stress for the respondent because they didn't show up, the downside is you're giving a blank check to the court to issue whatever they feel like. And if the petitioner's there, this person's terrible, blah, 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 and it's a court that's particularly aggressive, you could get stuff you really, really don't like. So what happens if the petitioner doesn't show up for a protection order hearing? Let's say the petitioner filed the temporary order and they don't want it anymore, or they just don't show up for some reason. Well, if the respondent is there, the respondent can make a motion to dismiss because, hey, default if the respondent doesn't show up, dismissal if the petitioner doesn't show up. And so if you happen to be a petitioner watching this and you don't want the order to continue, well, the safest way is just don't show up, right? But as far as the respondent goes, other things that you have to worry about, when you do show up is, hey, everything that you say in this court case is being recorded in one way or another. If you're accused of a crime, you start talking about that, that could be exposing you to evidence being used against you by police or by prosecutors if whatever brought you to court has been reported to police, right? We have to worry about that. And what you really want to do is talk to an attorney about what's the big picture. And in most of these cases, one of the first things that I ask a respondent who is talking to us about possibly helping them is, why is the petitioner doing this now? Right? What happened in life and what's been going on with your interactions that we think the petitioner is doing this now? Because more often than not, the complaints are about stuff quite a bit in the past. And because the RCW 7.105 protection order law is so rigged against respondents predicting the petitioner's behavior and thinking about how that behavior might be influenceable by actions that we take on the respondent side, is one of the most likely ways to end up with a successful outcome in a protection order case. So what are your options when you get served? You either appear or not appear. You either get an attorney or not. You either agree or you fight. In any case, you probably need to get some legal advice, but realize that there are possible unforeseen consequences if you just ignore it. So I hope you found this useful. If so, please like and please subscribe. More people get to see it. More people get the help they need. More importantly, if you've been served with a protection order, if you've got a criminal matter in Washington State, feel free to reach out to my firm. We've been doing this almost for 25 years next month, filming this in January 2025. And if we get on board, we'll listen to what happened, we'll identify a way forward, and we will be there for you. Thank you.